We'll just take a moment to set up our laptops. At the moment, we can't see Mr. Flynn.
Oh, I can see the panel.
That's better. Thank you. Mr. Flynn.
Yes. I am Vernon Flynn, and I appear with Laura Newton for the appellant. Mr. Mendes, senior counsel, appears with Mr. Dharmendra Punwasi and Mr. Rishi Das for the respondents. As the panel know, this is an appeal from the Court of Appeal of Trinidad and Tobago regarding the meaning of a provision in the Co-Operative Society's regulations of Trinidad. Now, the appeal centres on whether the Co-Operative Society had the capacity and authority to enter into a loan transaction and to grant security to a lender in respect of its indebtedness. Issues which arise on the appeal have been divided into
Mr. Flynn,
Mr.
Flynn, bear with me for a moment, please. First of all, there's a technical problem, I think.
It's just my larger screen isn't working. I'm sure it can be sorted out. Well,
right.
Okay.
Secondly, your voice is dropping, and we're missing, I at least am missing, some of the things that you're saying.
I am so sorry, my lord.
Not at all.
I did go through the test, and I just, let me just see if I can turn up my volume.
I have a box with Mr. Rampersad.
Does that help?
Yeah.
Is that clearer?
That's clearer.
Yes.
Bear with us just one moment. Just bear with us just one moment, if you would. Thank you. Mr. Mendes in a box on the screen. Yes, Mr. Flynn, I'm sorry about that. We'll try again.
Can you hear me clearly now?
Yes, thank you.
I'm very grateful. I was just saying that the appeal centres on whether the Co-Operative Society had the capacity and authority to enter into a loan transaction and to grant security to a lender in respect of its indebtedness. And the issues which arise on the appeal have been divided into 5, and both parties have set out their cases in some detail in writing. And those issues have been dealt with in a logical order, following the way in which the case was presented to the courts below. But I would like to begin my oral submissions and focus upon dealing with what we submit as the most striking aspect of the decisions below, and that is the failure to apply the indoor management or the rule in Turquoise's case. At common law, for at least 165 years, a person dealing with a corporation, assuming that he or she is acting in good faith and without the knowledge of any irregularity, need not inquire about the formality of the internal proceedings of the corporation, but is entitled to assume that there has been compliance with those internal requirements. And there are at least two policy reasons in support of the indoor management. Firstly, it will be an unfair imposition on the outsider who has no right to demand proof by the directors that the requirements of the Articles of Association or bylaws or other internal matters have been fulfilled. And secondly, the constant duty of verification would impose an impractical burden. And the difficulties which arise if the indoor management rule is not applied are amply demonstrated by this case. Now, if we're right about this, namely that the courts below should have, but did not apply the indoor management rule, as we submit we are, we succeed on the appeal on that basis alone. The other grounds fall away because they're concerned with internal management issues or are otherwise not necessary to decide. Indeed, some of the other grounds and the pleading points taken illustrate precisely why the indoor management rule ought to have been applied in this case. Now, it's common ground that SR Projects, the appellant, advanced to the HCU a considerable sum by way of a loan, nearly 19 million Trinidadian dollars or 2.8 million US dollars. It initially loaned 1.5 million US dollars in October 2004, and by January 2005, the advance increased to a total sum of over 2.8 million US dollars. And that was done at a time when the HCU's deposits were in excess of 860 million Trinidadian dollars, or 126 million US dollars. And the society drew on the loan facility in full and made monthly interest payments and one capital payment of US $256,000 between October 2004 and October 2006. Now, the liquidator contends that at that time, at the time that SR Projects advanced its loan to the HCU was in breach of its maximum liability, fixed following the meeting of the HCU on the 17th of April 2004 and approved by the Commissioner in the sum of 100 million Trinidadian dollars or 14.7 million US dollars. But how was SR Projects to know this? There is no suggestion at paragraph 51 of the Respondents' case, which deals with the knowledge of SR Projects through its decision maker, Mr. Shamsuddin, that SR Projects actually knew that the HCU was in breach of its maximum liability. Nor is there any suggestion at any stage of bad faith or knowledge or notice in this case.
I would like to ask a question.
Sorry.
I would like to ask a question. As a prudent lender, did SR Projects ask the HCU for a certificate as to the amount of its borrowings and that the borrowing limits were not exceeded? One would suppose that a prudent lender would have asked for such a thing.
Well, my lady, can I take you to page 128 of the bundle? You will see what the case is. I think the short answer to your ladyship is no, they didn't ask for that certificate. But what they do set out at paragraph 51 is what their case is in relation to what was known. Now, in my submission, the short answer to your ladyship's point, and I'll come to the cases in relation to this, is that that would be a matter of the internal compliance. In other words, that would be a matter that the appellant is entitled to assume had been properly done. We accept, as I'll come to, that my clients did need to know, and in fact did know, but would have been taken to know external matters.
But don't we have
not internal matters such as that.
The statute to find, don't we have to start with the statutory material to discover whether this is a matter of internal management?
Yes, my lady, we do have to do that. And I'll come to it in a moment. The short answer to your ladyship's question is Regulation 14 doesn't tell you what the limits are, and nor could it ever tell you whether there's been compliance with those limits. And so there is a divide between external matters, the statute, the bylaws, the regulations, which set out the position that an outsider is taken to know. Those are the external matters, but not the internal matters. And at the heart of this case, what this case is concerned with is those internal matters. Whether or not there had been a breach in my submission was an internal matter. A lender is entitled to assume that there has been compliance. He doesn't, in my submission, have to ask for a certificate. He's entitled to assume that that has been done. Your Ladyship, just so the panel knows, paragraph 51 sets out what the case against us is in terms of what my clients say to have known. And they say it was clear, for example, if you have 128R, clear from my client's evidence and cross-examination, he was familiar with the regulatory and legislative regime, and specifically the acts and the regulations. He'd requested and read the bylaws. He'd read Regulation 14. He formed the view that and consulted with other lawyers. He formed a view on Regulation 14. He was said to have had an obligation to ensure that it was within the maximum liability and so on. All of those matters take all the way down to G. Now, in my submission, my clients were actually paragons of what they were required to do in those circumstances. But what my client and indeed other litigants are not required to do is to somehow work out whether there had in fact been compliance with the particular regulations as a matter of internality as opposed to externality. So that's why in my submission, I do submit that SR projects couldn't have known this. They could not have known, and it is not a case against them that they did know. There's no suggestion of bad faith or notice that there had been a breach of the internal requirements. Now, in my submission, if one applies the indoor management rule, the rule laid down in Turquin's case, as a third party, my client was entitled to assume that those matters of internal management had been carried out. And we accept that we should be taken to know that a cooperative society would be subject to rules or regulations, including in this case, restrictions on its borrowing. That is, in my submission, the external information. And as I say, the evidence shows that SR projects, through Mr. Shamsuddin, did in fact know that the HCU had restrictions on its borrowing. But even if he did not, he would have been taken to have knowledge of that, as well as the contents of the published information, the Cooperative Societies Act, the bylaws, and the regulations. But in my submission, the appellant and no outsider can be expected to investigate the internal affairs of the HCU. It is entitled to assume that the HCU had complied with those relevant requirements. Now, the case against me, the respondent contends that the relevant knowledge includes not only knowing of the existence of a maximum liability in principle, but also knowing what the maximum liability was from time to time, which varies from day to day, if not hour to hour, indeed possibly minute by minute, knowing what approval had been sought and granted from the Commissioner in respect of such maximum liability, and indeed knowing even in what form such approval had been granted or ought to have been granted, and knowing at the precise moment that it would advance sums to the HCU, whether the Society's constantly fluctuating deposits were at that precise moment below of or in excess of the total maximum liability for loans and deposits.
Well, it may be that the HCU was borrowing very close to its limits, but it could have left a sufficient buffer to account for changes that occur daily.
Yes, my lady, and that's why I emphasise that there is no case against me of notice. And I accept that notice might arise in a number of ways, which is it may be that one, if the limit is, let's say, I'll give you an example, the limit is $10 million and the loan is almost 10 million or close to it, that would be a matter that might put a party on notice. But this is not a case about notice. There's no, as I say, there's no case against me about notice or bad faith or anything of that kind. And that is what it comes to in my submission, which is absent a case of notice or bad faith or something along those lines. It isn't for my client or any outsider to investigate these matters. They're entitled to assume that there's been compliance. And that is why when one looks at the pleading point raised against me as to what approval was granted by the Commissioner in respect of the HCU's maximum liability, that is a vivid demonstration, in my submission, of why the rule in Turquoine's case is necessary for this and other cases. How can it be for a third party to assess whether the Commissioner had in fact granted approval for a particular maximum liability in a sufficiently formalised way to meet the requirements of the statutory and regulatory provisions governing cooperative societies, or to be at their peril if they reasonably assume, for example, that the presence of the Commissioner at the relevant meetings where the liability is tabled, the maximum liability is tabled, that would amount to consent. And that is, in my submission, regardless of the merits or not of the pleading point, what it illustrates is how striking it is that the indoor management rule wasn't applied in this case. And we submit it would be impossible in practice, as well as undesirable in principle, for potential lenders to have to inquire into the affairs of a cooperative society to such a degree as to concern itself with matters of such detail as to whether the Commissioner had approved the maximum liability in writing, at a meeting, or in some other form, and whether that approval sufficed to amount to compliance with the external regulations.
Could I ask another question then, Mr. Flynn?
Of course, my lady.
This is a rule of agency that you're relying on, not a rule of ultra vires. At what stage did you raise this in the courts below, if at all?
I'm sorry, my lord, I missed the last part of your ladyship's question.
Did you raise the rule in Turquoine's case, Royal British Bank and Turquoine, in the courts below, if you did so?
Yes, my lord, my lady, I'll come to that, but I believe that we raised the issue. This issue turns on capacity,
no, it
or
doesn't.
ultra vires, properly so called,
The
or authority. It was always an issue before the courts at first instance and in the Court of Appeal whether this was properly ultra vires in the sense of the society didn't have capacity to do what it did.
The rule in Turquoine's case, is
yes.
separate from ultra vires.
Sorry, my lady.
The rule in the Royal British Bank and Turquoine is not a question of ultra vires, because if it's ultra vires, it's void.
Yes. But your ladyship is absolutely right. Your ladyship absolutely right. I'm going to the core cases on this to demonstrate why the indoor management rule should be applied in this case. Your ladyship is right. It is a question ultimately of ultra vires in the sense of a lack of capacity, or a question of authority and whether there's been a breach of authority. Well, now, in my submission, the indoor management rule applies here because it wasn't a matter of capacity in this case. It was an internal rule, and that is what Turquoine's case deals with.
I know that's what you want to argue, Mr. Flynn, but we're using the word ultra vires in two senses. There is the word ultra vires, the expression ultra vires, in relation to the capacity of the company or the credit union. There is sometimes said to be acts which are ultra vires the directors. That means it's outside their authority under the articles, e.g. to borrow in excess of the limits. Now that is not a question to which the word ultra vires should be used. That is, we know that from Rolled Steel, where the court said it was very confusing to do that.
Yes.
So if you're talking about, well, the director's power was inhibited, they couldn't borrow more than the limit approved by the Commissioner, that is, as I understand it, to be outside the scope of this appeal.
My lord, my lady, I don't believe it's outside. I think it's at the core of this, because the core of this appeal is, as your ladyship absolutely says, the difficulties that are used in terms of terminology of ultra vires. I am going to use that, if I may, as a synonym for lack of capacity. And ultimately, the decisions below have said that the HCU had a lack of capacity in this case. Now, in my submission, that is wrong. The HCU always had capacity to borrow and lend. There was an internal limitation on the maximum amount. A breach of that, in fact, did not mean that there was no capacity. That was outside the authority of the directors to do and has consequences. But it is not outside capacity, and it is not therefore ultra vires. It is so in using, I adopt everything your ladyship says in rolled steel. They made that very clear. And at the heart of this case is, was this truly a lack of capacity? And in my submission, it was not. Absolutely not. Now, the difficulties, as I say here, about the assumption of compliance is one of the core reasons why one has the indoor management. And that's why it was created and remains part of the common law.
Well, I'm
now,
sorry,
your ladyship will know probably better than anyone that in the case of registered companies, that has now been put on a statutory footing in this jurisdiction and indeed in Trinidad. But it remains a part of the common law. And the panel will know that when the HCU was registered under the Trinidad and Tobago Co-Operative Societies Act, it became a corporate body on registration. Now, the Act contains no equivalent to the provisions of the Companies Act. And so the indoor management rule we submit operates as a matter of common law in respect of cooperative societies in Trinidad and Tobago. Now, we have added, and I do want to show the panel the authorities on this, because what is said against me and what was said in the courts below was a reliance upon two cases, and I want to take the panel to those two cases if I do nothing else, because that is the foundation on which the entire case rests, because those two cases are said to go to capacity as opposed to authority. And I would like to take you to those. But before I do that, we have put up, I hope that the panel has it, we've sent it in a loose form, but the decision of the House of Lords in Marnie in East Holliford Mining Company. And the reason I put that case before the panel is because that is the case in which Turquin's case was authoritatively affirmed by the House of Lords. I just want to show you one extract from that, if I may. If you have it, as I say, it's loose, it will be page 25 of the electronic version, or in the judgment, it is at page 893. It's the judgment of Lord Hatherley.
I'm sorry, just before you go to this, could you help me? What is the principle that you derive from this authority that you're inviting us to apply?
It's a statement of the principle in Turquin's case. In other words, what my submissions I've just made, which are the indoor management rule, is such that a third party is taken to know and be bound by external matters, such as articles of association, in this case bylaws and the Act itself, but not of internal matters. It is entitled to assume that there has been compliance with those. And that's the reason.
Well,
it's a short passage.
You will have to show us with the link between this and ultra vires.
Yes, I will do that. I'm going to take you to the core cases that were relied on below, which are said to be against me, because in my submission they are not. I'm sorry, my lord. If I just show you, if I could just take you to this, it's 2 paragraphs. I don't know if you have it in front of you, but it's Lord Hatherley, and it starts, it's a point of very great importance.
Yes, we have that.
Yeah, it's a point of very great importance that those who are concerned in joint stock companies and those who deal with them should be aware of what is essential to the due performance of their duties, both as customers or dealers with the company and as persons forming the company dealing with the outside world. On the one hand, it is settled by a series of decisions in Ernest and Nichols as one, and Royal Bank, British Bank and Turquin, a later one, that those who deal with joint stock companies are bound to take notice of what I may call the external position of the company. I'm just pausing there. We completely accept that. Every joint stock company has its memorandum and articles of associate. Every joint stock company, or nearly everyone I imagine, has its partnership deed under which it acts. Those articles of association and that partnership deed are open to all who are minded to have any dealings whatsoever with the company. And those who so deal with them must be effected with notice of all that is contained in those 2 documents. Again, on this appeal, we accept that. We are taken to have known whether, in fact, we did know, as a matter of fact, we knew. But we would be taken to know of the Act, the bylaws, the regulations. After that, the company entering upon its business and dealing with the persons external to it is supposed on its part to have all those powers and authorities which by its articles of association and by its deed it appears to possess, and that all directors do with reference to what I may call the indoor management of their own concern, is a thing known to them and known to them only, subject to this observation, that no person dealing with them has a right to suppose that anything has been or can be done that is not permitted by the articles of association or by the deed. So, my Lord, that's why I wanted to show the panel that decision. So the indoor management rule, established latest by the Turquin case and upheld in Marnie, is obviously problematic for the liquidator in this case, because they seek to distinguish Turquin on the basis that whilst third parties dealing with company directors are entitled to assume the necessary internal steps have been taken, they say this has no application to legislative requirements, which all persons need to be aware of and check to ensure compliance. Now, in my submission, there's no principled basis for such a distinction. Regulation 14 is publicly available, and we accept that it has to be taken as having knowledge of its existence. And we did have such knowledge as we accept. But to adopt the phrase used by Lord Hatherley, the appellant had adopted all the external information they could upon the subject. But knowledge of the existence of Regulation 14 is irrelevant if the potential lender doesn't also know whether the society is at any given point in time running below or above its maximum liability. Now, in my submission, there is no way for a lender to ascertain the amount of liabilities held, other than from the company's internal information, and no way to cross-check that information. And that is why the rule in Turquin is so essential, because even the most careful lender cannot be sure that it's transacting within the maximum liability. The other grounds of appeal highlight that very difficulty, construing the limitations as a matter of law, what they were, and whether any increase was actually binding or not. Now, as I say, the respondents rely very heavily on two cases in this respect. One is the case of Chaplio and the Brunswick Permanent Building Society, and the other is Credit Suisse and Allerdale. And I do want to take the panel to those two cases. What they say is in relation to Chaplio in their case at paragraph 103, you don't need to turn it up, but what's said against me is, persons dealing with a corporation having a limited power of borrowing are put upon inquiry as to whether that limit is being exceeded. But the propositions advanced by the respondent on the basis of both those cases is not right. Both Chaplio and Allerdale are very unusual cases, neither of which bear any analogy to the present case. And certainly neither of them justify a departure from the application of the indoor management in this appeal. Now, can I take the panel first to Chaplio, which is in the electronic bundle at page 1194. And I'll just tell you, the panel, what that case was about. You can see from the very first line of the headnote, it was an unincorporated building society. That was what the appeal in that case concerned. And in that case, the directors of the unincorporated building society placed advertisements to the effect that loans could be made by bringing money to the society's secretary. And in each case, the secretary gave a receipt for the loan with a written undertaking by the secretary to procure, and I quote, to procure the promissory note of the directors for the loans. Now, the society borrowed an amount exceeding that set down in its certified rules, and then a further sum was paid to the secretary by Mr. and Mrs. Chaplio. The secretary made off with their money, and the Chaplios sued the society and the directors for the return of the loans. Now, by the time the matter reached the court, the society had admitted liability for 4 out of the 5 sums loaned, and the action concerned only the recovery of the final £100 advanced, for which no promissory note had been given to the Chaplios. And the court held that the society's borrowing limit had been exceeded at the time the Chaplios' final loan was made, and that the society had derived no benefit from the loan, and so it wasn't liable. Now, in short, just to summarise the case as it's described in Bousted and is very clear from the headnote, the directors of an unincorporated society held out the secretary as having authority to borrow in excess of the amount prescribed by the rules of the society. the Secretary borrowed in excess of such and misappropriated the money. It was held that the directors were personally liable to the lenders on an implied warranty of authority, even though they hadn't acted fraudulently. But it's of none or limited assistance in this appeal because Turk 1 was only cited in argument, not in the judgment, because this wasn't a case of the corporate entity at all. Now, what's relied on by the respondent is the dicta of Lord Justice Bagley in the electronic bundle at page 1210. And what is said there, if you look at the bottom of the page, it said it's also been urged upon us that the plaintiff had no means of knowing or ascertaining whether the society had exhausted its powers of borrowing or whether indeed there was any limit to such power. To this argument, I can only reply that persons who deal with corporations and societies that owe their constitution to or have their powers defined or limited by acts of parliament or are regulated by deeds of settlement or rules, deriving their effect more or less from acts of parliament, are bound to know or to ascertain for themselves the nature of the constitution and the extent of the powers of the corporation or the society with which they deal. The plaintiffs and everyone else who have dealings with a building society are bound to know that such a society has no power of borrowing except such as is conferred upon it by its rules, and if in dealing with such a society they neglect or fail to ascertain whether it has the power of borrowing or whether it has any limited power it may have has been exceeded, they must take the consequences of their carelessness. Now, in this case, there is no carelessness or any failure to ascertain the external requirements. Now, it appears in this case that what happened is, perhaps unsurprisingly, the Chaplios didn't make any investigations at all as to the relevant powers. In other words, in that case, it looks like they looked neither to the external rules nor to the internal ones. If you go on in the report to 1213, you'll see what Lord Justice Brett says at the bottom. It's quite interesting because in my submission, properly read, this case actually confirms the indoor management rule rather than a case against it. It's about halfway down where Lord Justice Brett says, if the society had an unlimited power to borrow, but had nevertheless given secret orders to its agent not to borrow beyond a certain amount, I should have thought nevertheless the society was bound, because the plaintiffs would not have been called upon to inquire as to any secret. But where a society or a company has upon the face of its constitution, that is either by the statute or statutory rules under which it is constituted, only a limited authority to borrow, then it seems to me that a person dealing with such a society must either inquire or run the risk. And then he says at the bottom, 4 lines down, the plaintiffs didn't inquire, and though probably if they had inquired, they would have learnt nothing. Yet that's their misfortune, and they're debarred from recovering against the society. Now, one of the key factors which weighed with Lord Justice Bagley was the fact that the society didn't have the benefit of the loan in question because the secretary had made off with it. And you'll see that in 1209, the electronic bundle. And he says right at the bottom of the page, about 7 lines from the bottom, this is Lord Justice Bagley, if the society had received the benefit of the £100, if, for instance, that amount has found its way to the credit of their banking account, the plaintiffs might, upon the authority of some of the decisions which have been cited on their behalf, have been enabled to establish a claim against the society to the extent of the benefit derived by them from the transaction. But no such benefit was derived from the society, by the society from the transaction with which we are dealing. So he emphasised that if the society had received the benefit, there might have been a claim against it. And we submit that's an important part of the reasoning. And then if you look at 1212, again, Lord Justice Bagley, one other factor that was important in this case is if you look halfway down the page, paragraph beginning, I do not dissent. He then says the evidence into which I need not enter in any detail satisfies me that after the directors well knew that the power of borrowing had been exhausted and that any further borrowing would be contrary to the constitution, the rules of society, and therefore wrongful, they authorised Keeley to continue receiving money by way of loan on account of the company, and to do so in the same way as they had previously received money borrowing powers were exhausted, and so on. So it was an important part of that the directors well knew that the power of borrowing had been exhausted, and any further borrowing would be wrongful. Now, in short, in relation to this case, now this case is supposed to be the foundation of the case against me. And it's only this case in Allerdale that's relied on. There is no textbook or other case which begins to demonstrate that this decision in Chapman makes inroads into the indoor management in relation to corporate entities, such as in this appeal, particularly a corporate entity such as the HCU, whose function is deposit and loan. Now, at most, it might be suggested that the rule is applied differently to an unincorporated building society, as we have in Chapley, where the key issue was authority, as my Lady Arden pointed out. Critical issue there was authority and the holding out by the directors. Or where there's a situation where there's no actual benefit received, as here. There was no actual benefit here to the society. Now, one can see that the result in that case perfectly explicable on the facts of the case. But in my submission, there is nothing to show in any way that this case supports the principle that is relied on against me, or indeed in the courts below. The next case that I need to show you is the decision of Credit Suisse in Allerdale. That's at page 1284 of the electronic bundle, where Chapley was upheld by the Court of Appeal. It's of interest also because it was an appeal from Mr. Justice Coleman, the same Mr. Justice Coleman, or Sir Anthony Coleman, who had the privilege of writing the Coleman into the collapse of the HCU. Now, if you just have a glance at the head note, I'll just tell you the facts and why we submit that the decision in Allerdale is even further removed from the facts of this case. What Allerdale concerned was the acts of a local council which acted in excess of its statutory powers in relation to the construction of a swimming pool. What happened in that case was that the council created a company to develop a site for a leisure pool and timeshare units and borrowed money to fund the development on terms that the borrowing was guaranteed by the council. When the company went into liquidation, the bank looked to the guarantee to recover the sums loaned, and the court held that the council had no statutory power to give a guarantee for the company's borrowing. And in the words of Lady Arden, that was properly ultra vires. That was a question of whether it was truly outside the capacity of the local authority to do what it did. And you will see that the court was particularly concerned by the fact that the establishment of the company and the giving of the guarantee were part of a scheme to circumvent the controls imposed on local authority borrowing. And therefore, it was ultra vires the powers of the council. And that's not just me saying that. You can see that from the second finding in the head note, page 1284. The establishment of the company and the giving of the guarantee were part of a scheme designed to circumvent the controls imposed on local authority borrowing under the Local Government Act, and fell outside both the express and implied powers of the council, and were therefore ultra vires. One only has to look at that case to see it is very, very far removed from what the panel is concerned with on this appeal. In other words, this was a genuine case about capacity, not authority. Ultra vires properly so called. That was why in that case the guarantee was unenforceable. And Allerdale was concerned with a local authority. We submit very different entity to a cooperative society such as the HCU. A local authority is a public body susceptible to judicial review if it acts in excess of its powers. And we submit that the HCU, a cooperative society, is far more akin to a registered company than to a public body. And we submit here, the issue in Allerdale was very different because in Allerdale, it was about whether or not the local authority could circumvent the requirements, statutory requirements on them by doing what they did. Here, the panel is concerned with an undoubted power of the HCU, but subject to internal limitations. We submit that's why it's, in my submission, very plain that the that the appeal before the panel is not concerned with capacity, properly so called, as opposed to Allerdale, which was concerned with capacity, properly so called, of the local authority's ability or power or capacity to enter into the transaction at all. And we submit that it's plain when one reads this case, which did give rise to some quite difficult issues, but the context is very, very different to here. And I do want to show you, because this is so important, this case, what Lord Justice Hobhouse, as he then was, said. Okay, so if you go first of all to 1326 of the electronic bundle, you will see that there is a distinction drawn very clearly between about the status of a local authority, because here what was happening was there was to a certain extent an interplay between public law and private law. The transactions were private law transactions, but the context was the local authority. Lord Justice Hobhouse says at D, the bank's counterparty was a local authority. Local authorities are statutory corporations. They carry out governmental and administrative functions and have powers of taxation. They're governed by a complex scheme of legislation which regulates to a greater or lesser degree every aspect of their activities and finances. The legislative scheme is subject to continual revision with additions and amendments to the legislation. It is therefore necessary to have in mind that the present case has to be decided by the legislation in force in May 1986, and later acts would have been relevant if they'd been in force at the time that it was done. And then, unlike natural persons of full age and companies under the Companies Act, local authorities are corporations of a limited capacity and competence. And then any third party dealing with a local authority should be aware of that fact and potential legal risk. He then says at 1330, at 352B, if local authorities were companies incorporated under the Companies Act, the Rolled Steel case would provide the necessary guidance on treatment of lack of capacity and excess or abuse of power. That's the point that Lady Arden made earlier, which is that's a critical distinction, capacity and power. But local authorities are public law bodies and fall within the purview of administration. This means their decisions are amenable to judicial and the remedies which that procedure provides. And the third extract is at 1333, please, the electronic bundle, at G to H. He says that in my judgment, the answer lies in what has been said by Lord Hailsham and Lord Diplock in the passage that I quoted, and the recognition that the terms that are used differently in administrative and other branches of the law, again going back to what Lady Arden says, which is you must be careful about use of terminology in these circumstances. Before using the phrase ultra vires or the words void and nullity, it's necessary to pause and consider the breadth of the meaning which one is giving them. It is not correct to take terminology from administrative and apply it without the necessary adjustment and refinement of meaning to private law. Where private law rights are concerned, as in the present case, the terminology must be used in a sense which is appropriate to private law. Now, that's very important in this case, because it's not the bright line test that the respondents rely on or the court below applied. In this case, in my submission, it's a private law case where the question is, did the HCU have capacity to lend and borrow? And in my submission, it plainly had capacity. Internal limitations are subject to the rule in this case. And they are matters that a third party is entitled to assume would be complied. So you have two very different cases on which the edifice of this matter relies. Chapleo, which was an unincorporated building society, which was about the authority of directors, where there was no benefit at all to the society. And at the other extreme, Allerdale, which is a case about a local authority trying to circumvent the statutory restrictions imposed upon it in order to do something it simply didn't have the power or capacity to do. In my submission, very, very, very far off from the case before the panel. And in my submission, the reference to rolled steel by Lord Justice Hobhouse is apt. As we explain in our written case, Where a company exercises a power which it undoubtedly possesses, but for a purpose which is ultra vires, and those are cases dealing with abuse of a power, not with capacity. And in those circumstances, those transactions are enforceable against the company unless the outsider had noticed, actual or constructive, that the transaction was in excess of or an abuse of the company's powers. And in Allerdale, you see, the distinction was drawn between companies and public law bodies, which fall under the purview of administrative law and are amenable to judicial review. And what they were concerned with was whether there was capacity, properly so called, for the local authority to enter into that particular contract. It was not concerned with an undoubted power with internal limitations on the exercise of that power. And there is certainly nothing in that case, either of those cases, that put forward any type of bright line test to the effect that the indoor management is to be ignored or discarded or distinguished in this case. This case is a credit union, a cooperative society, whose function is the lending and borrowing of money. And that's why we submit the indoor management is at the heart of this appeal. And if the panel accepts my submissions on this point, we are in the realm of the indoor management law, and therefore the appeal succeeds on that ground alone, so as to enable my client to do what in my submission would be an unsurprising and just result, that it can enforce its security.
May I ask, just before you move on, may I ask this? Ultimately, do you not have to find this unlimited capacity in the relevant legislation or the rules made under the legislation as a matter of interpretation of those provisions?
It depends what your lordship means by that. Can I put it this way? We accept that Regulation 14 has a statement about the limitations of maximum borrowing. In other words, we accept that an outsider would see that and is taken to know that whether or not they actually in fact do know. But that is an externality. In other words, what our submission is that the indoor management rule applies in this case just as much as it would apply anywhere else. If we were dealing, for example, with a company under the Companies Act, and the same regulation were to be found in the Articles of Association, the outsider would be taken to know that, but they would not be taken to be, unless they were on notice or allegation of bad faith or so on, they would be entitled to assume that those internal matters had been complied with. So I don't accept, my lord, that this would apply. For example, I think the consequence of your lordship's question is, if you had something along the lines of Regulation 14 in the Articles of a company, or indeed as you have here, that would automatically mean that an outsider is at peril of there being a breach. And I don't accept that.
No, my question to you is, I beg your pardon, my question is this: were we to come to the conclusion that properly understood, the legislation and these various provisions made under it constitute a prohibition against the society borrowing in excess of these limits, then Turcan's rule doesn't assist you at all, does it?
It does, my lord. I don't accept that. I don't accept that. It does because the Turcan's rule makes a clear distinction between the external and the internal. And I do not accept that it means that there is no capacity to lend or borrow, for example, in this case, in the HCU. In the similar way that if we were outside the HCU and we were in the realms of a company, a normal company under the Companies Act, and it had a similar statement in its articles, that it had a maximum limit, either by reference to some formula or indeed even by reference to a particular sum, that would mean that an outsider would be at peril because the capacity of the company is limited, and therefore borrowing in excess of that would be outside its capacity. I don't accept that. My submission is that is whether there's been compliance with that, in fact, is an internal, not an external matter. Now, to reach that conclusion in this case would mean that the panel would have to conclude that some different rule applies because you're dealing with a company under statute as opposed to a company under the Companies Act. And in my submission, there's no principal distinction here. There may be distinctions as you get in Allerdale, where you have a local authority, and in some cases, you'd have the imposition of public law issues. I accept that Allerdale is one such example of that. But in my submission, the question your lordship asked me, the answer is no, it does not go to capacity. And I would turn it around the other way and say, what would be the principled reason for the disapplication of the indoor management rule in these circumstances? Because effectively that's what it would be. Because as I say, if it were a company, a limited company under the Companies Act, that wouldn't be an answer. It wouldn't go to capacity. It would go to authority at most. And it would have consequences, of course. It would make the directors liable and so on. I'm not suggesting otherwise. But it doesn't go to capacity. And as I say, the reasons underlying the indoor management are very sound policy reasons. That is that the outsider shouldn't have to inquire absent notice and bad faith as to whether the internal requirements have been complied with. As I say, when one looks at the other issues, I haven't got very much time to deal with it, but when one looks at the other issues, the pleading points, for example, one of the issues is how long or who was there from the commissioner, or is the presence of the commissioner at the meeting at which the maximum borrowing is approved? Is that sufficient to amount to consent from the commissioner? And why should an outsider lending money to the HCU be concerned with those? Why should the outsider have to decide whether as a matter of law or a matter of fact, or on some other basis by conduct, whether they should, that binds the HCU?
You referred to the decision in Turkwan's case
yes.
as basically your primary authority. Are you going to open it to us or not?
Well, I absolutely can, but the reason I took you to Marnie was really to show you what that was. I assume that the panel would understand what the basis for that, for the decision in Turkwan. I don't think there's anything controversial about the way in which I've stated the rule, the internal management rule, or indoor management rule, as it's called. I don't think there's anything controversial about that. The only issue is whether it applies in this case. And in my submission, there's been no principal basis for any basis for not applying that.
But you've not shown us any case in which where a corporate vehicle has a limitation on its capacity, the indoor management rule can be relied on. Marnie is a case of where there were limits in the Articles of Association.
Yes, my lady, but the principle is the same.
Well, there must be authority if it is.
Regulation 14, it is, we accept that we are taken to know what the externalities are. So we're taken to know, in this case, the statute, the bylaws, the regulations. But what we're not taken to know on the basis of Turkwan's rule in Turkwan, the indoor management, to use shorthand, is whether there has in fact been compliance with that, i.e. the internal matters. I don't understand, the reason I haven't taken to use that, I can do if you would like, but I haven't taken to that because I don't understand that to be controversial. What's said is, it doesn't apply in this case. Not that there's any other reason, it's simply that it doesn't apply. And I do submit that that's at the heart of this case. What is the principal reason upon which the decisions below were given to effectively disapply that rule? And in my submission, there isn't any. None has been suggested, and in my submission, there isn't any. The most in my submission that could be said is, when you're properly dealing truly with a case like Allerdale, properly capacity so-called, ultra vires properly so-called in the public law sense, then that can impinge upon private law rights. But here there is no basis given whatsoever for the disapplication of rule. And the cases I've shown you are the two cases relied on, Chapley and Allerdale. And in my submission, they don't begin to justify the approach taken by the courts below.
Well, you've asked a rhetorical question, but why don't you try and answer it? Why did the courts below disapply the rule in Turquin's case?
Well, that's very difficult to answer, my lady, because one can only read the judgments, and the only cases relied on are Chapleo and Aladale, and they don't get there in my submission. They're not supported. And if one does ask the question, what is the principal distinction here? In my submission, it's very difficult to identify a principal distinction. Why, if you're dealing with a company and you're under rolled steel and you apply those very particular rules about capacity and authority and the indoor management rule, why do they not apply it in this case, in a case in which you have a society whose function is to borrow and loan money?
As I understand it, one of the points that's taken against you is that the Act doesn't contemplate the HCU or indeed any other society of this kind regulating itself, and that the Act and the legislation empowers regulation and oversight by the Commissioner, and that when one looks at this scheme as a whole and the regulations made under it, and one appreciates that one is not dealing here with a society with unlimited liability, the interpretation of the legislation and the impact of Regulation 14 in this context is in fact to impose a limitation on the capacity of the society to borrow or take deposits beyond these limits. And ultimately, hang on, just one moment. It may be said against.
There's a certain time lag, Mr. Flynn. You're going to have to be a little patient to wait for the full question.
It may be said here that you're really advancing to us a bootstraps argument, that you're assuming what you're seeking to establish by your argument, and the approach adopted by the courts below, and indeed, as I understand it, by the respondent, is to say that one must start by looking at the scheme as a whole, and then the specific wording of these provisions in question in the light of that scheme, and in that light, properly interpreted, the contentions that you're advancing are misconceived.
Well, I'm sorry, I hope your lordship's finished.
Yes, thank you.
Can I put it the other way around? Your lordship used the bootstraps argument. In my submission, that question and the approach taken by the respondents is in fact the bootstraps argument, because what it assumes is that the scheme defines the capacity, and I don't accept that. If one takes the starting point as what would be the position if this were a company under the Companies Act, either in England or in Trinidad, where the article said expressly there is a limited power of borrowing, by reference, as I say, to a formula or exactly as it is in Regulation 14. That wouldn't be a limitation on capacity in those circumstances. Even if it's said very clearly, the position would still be the same. It would go to the company would have the capacity to borrow, but it would be a breach of the director's authority to exceed that. But it has the capacity to do that. It is not ultra vires the company. Now, similarly, the fact that this is done by way of an act of parliament under regulations and bylaws does not give rise to a principal distinction. There is no bright line distinction. The most that could be said against me is that a case like Aladale, where you are concerned with public law questions about genuinely capacity of avoiding a scheme, that would have an impact. I accept that completely. But we're very far removed from that. The real issue here is what is the principal distinction between a company under the Companies Act and the credit union here? And if the only distinction is one is by way of a corporate vehicle under the Companies Act and the other is by way of a corporate vehicle, corporate entity under some other act, in my submission, that isn't a tenable distinction. And what happened below is it just simply appears to have been proceeded on, in my submission, a bootstraps argument, which is because it says so in the in Regulation 14, interpreted contrary to our case as to what it actually means. But even if it were meant what it was said to mean, that in my submission doesn't go to capacity any more than it would for a limited company under the Companies Act. So that in a sense is a bootstrap argument. It's not my argument, which is on my submission, which is bootstraps. My submission is there isn't a principal distinction, not in this case. There may be in other cases. There's no bright line distinction simply because it's a company incorporated under an act as opposed to the Companies Act. And I rely on all of the common law position on very well-established rules, Turquoine's case, Rolled Steel, all of those very sensible policy-based rules and reasons. And why is it different here? And in my submission, no reason has been given, and the reason that no reason has been given or suggested is there isn't one, other than the mere fact that it's under an act which is different to the Companies Act. That does not give rise to that reason. No third party can work out whether the maximum is breached. They know of it, they can't work that out, nor should they need to. It's impractical and wrong in principle, as the cases say. So the real question is not what the rule is. I mean, I don't think there's any real controversy about what the rules are. It's whether they apply. They've been disapplied here, and the issue is why. And as I say, no principal reason has been given for that. And as a result, my client's lost his security on the basis of these decisions.
Thank you.
So yes, I totally accept. I would adopt bootstraps, but turn it around the other way. Now, I can see I've got, I think, something like 9 minutes to deal with the other points. I mean, I'm slightly in the panel's hands.
You had a delayed start, You had a delayed start, Mr. Flynn. So you have a little more than that.
I'm very grateful. So I'll try and deal with it as quickly as possible in terms of the first substantive issue, which is what is meant by maximum liability. The panel will know well what Regulation 14.1 says. It says every society shall from time to time fix at a general meeting the maximum liability it may incur in respect of loans or deposits, whether from members or non-members. And just to summarise the respective positions, it's my client's case that the proper interpretation of that regulation is that a cooperative society could set separate maximum liabilities for loans and deposits, and that the two categories weren't subject to a single maximum. And as a result of that, the loan didn't in fact breach the HCU's maximum liability. The respondent contends, and the lower courts held, that Regulation 14.1 is to be read as providing for a single maximum liability for a society's loans and deposits. And the loan therefore exceeded the society's maximum liability, and they say as a result was void and my client's security unenforceable. And we say that a thread running through the submissions, the respondent submissions, is that we say that the liquidator's interpretation of Regulation 14 lies in the face of commercial common sense, because it's at odds with what actually happened in this case. All parties conducted themselves on the basis of the HCU's maximum liability.
Mr. Flynn, there's a question for you from Lord Stevens.
I understand that the respondents now agree that separate limits can be applied for loans and for deposits. I think their argument is it wasn't. It's more a factual argument.
You're absolutely right. We're very grateful for that acceptance. So just to re-emphasize, my clients advanced $2.8 million at a time when the deposits were in excess of $126 million. And neither the HCU nor my clients considered that the HCU was in breach of its maximum liability as a result of holding those deposits. The maximum liability was fixed at the general meeting of the HCU on the 17th of April 2004 at Trinidad in $100 million. It was approved by the Commissioner on the 25th of June 2004. And the Commissioner, who was responsible for the oversight of cooperative societies, made no complaint about the HCU. And we say it's an important feature, in fact, that at all relevant times, the deposits of the HCU were well in excess of the 100 million Trinidadian dollar limit, which the liquidator contends was fixed at as their maximum liability for loans and deposits. And it's an important feature that the Commissioner himself attended a number of the annual meetings at a time when the deposits of the HCU totalled hundreds of millions of Trinidadian dollars. In other words, well in excess of the 100 million alleged limit. And indeed, the Commissioner's representative was present at the very meeting on the 17th of April 2004, at which that limit was fixed. Now, at none of those meetings did the Commissioner or his representative speak up to say, as surely would have been done, the Society is wildly in breach of its maximum liability, which applies to both loans and deposits. And now, it's the liquidator's interpretation of Regulation 14 consistent. The liquidator's interpretation of Regulation 14 isn't consistent with what happened when the affairs of the HCU are unravelled. If the liquidator is right, the HCU had for years been accepting deposits from unsuspecting members of the public that were in fact in breach of their composite maximum liability for loans and deposits. And on the liquidator's analysis, they would have all been null and void. Now, at no point, in fact, was that actually suggested by anybody. In fact, as the panel knows, what happened was the government of Trinidad and Tobago bought out the deposits. And we submit that shows they couldn't have considered that they were null and void. And what they say, they've changed their case on this as well, Stevens, which is they say the liquidator has never contended that the deposits made by the members of the public were null and void.
Yes, but Mr. Flynn, the government could have decided to bail out the depositors because it felt that the regulation had been inadequate and that it might be under some liability for that reason. It's nothing to do with the questions we've got to decide as a matter of law.
It might be, Your Lady, that's right. But what I'm getting at is, what did they say? What did the liquidators say? And what they say at paragraph 85 of their case is, they say that the liquidator's position has always been that no one should have any money which was transferred, either by way of loan or deposit, forfeited. But that is exactly what the effect of what they said all along in relation to my clients. Because at the outset of these proceedings, in their statement of case, you don't need to turn it up because we haven't got enough time, but it's paragraph 20, subparagraph D, at page 474 of the electronic bundle. They say the transaction was void and unenforceable. And it's common ground that the only recovery for unsecured creditors in the insolvency of the HCU will be 20 cents on the dollar.
Yes, but you have to prove as an unsecured creditor for the principal amount. That was the amount of value which you gave to the company, to the credit union.
Yes, we say we gave the full amount. My point, my ladies, is a slightly different one, which is this, that the liquidator's case against my client has been that the transactions are null and void. And if the transactions in relation to my client are null and void, they're null and void in relation to everybody.
But Mr. Flynn, what the liquidator's case has been in the past isn't the matter. But B, the point is made that you've got a restitutionary claim, and so have they. The difference here is that you claim to be a secured creditor, but the depositors are entitled to their money back.
Yes,
just as you are.
Your Lordship's right. We may have a claim in restitution, but we certainly would lose our security. That is absolutely right. But my point is simply this, that the analysis put forward by the liquidator during the proceedings leads inexorably, in my submission, to the conclusion that the deposits were also void. And they say it's completely separate. We don't accept that. Now, I haven't got time to go through. We've put forward both semantic justifications for our case, textual and contextual justifications. I don't have time to deal with those. I'm very happy to deal with any of the... I see that my time is rapidly coming up, and I'm not sure I can actually even finish any of the other grounds, but I'm very happy to deal with... We've set out our case in some detail in writing, but I'm happy to take any of the issues that the panel particularly want me to deal with of the 5, if that would be helpful.
Thank you, Mr. Flynn. Well, if that concludes your submissions, we'll take a few moments to take stock of where we are. Court will rise.
Was they did not apply the rule in one's case. And I noted that Lady Arden asked my learned friend whether that question was raised in the court below. And at another point in time, she asked what was the court, how did the court deal with the one point? And my learned friend hasn't answered those questions as yet. And the reason is because the rule into one's case was not pleaded. The rule into one's case was not raised in this instance, and it was not raised in the court of appeal. So that you don't find the first instance judge or the court of appeal dealing with that argument at all. The Appellant's case in the law was that the maximum liability that had been set in relation to borrowing only, not deposit. Therefore, it had not been exceeded by the particular loan.
Sorry.
A point was also made that this did not go to capacity, but insofar as the facts of the case concerned, what was alleged was that there was a stop from alleging that the maximum liability had been exceeded, having regard to certain representations that have been made to Mr. Shamsuddin, but that point in time was acting on behalf of the appellant. So that it was never pleaded that this was an internal management matter, and consequence had to notice to the appellant had to be shown. And for example, complain that we never established that there was notice. We never argued that there was notice. The simple reason for that is that rule into one's case was never an issue in the courts below. It was raised for the first time in the learned friends.
I'm very sorry, I can't hear Mr. Mendes. Mr. Mendes, I'm having very grave difficulty. I'm not even sure this is being recorded because of the difficulty.
Mr. Mendes, I'm sorry, it's not your fault. But there is a problem with hearing at the moment. Both my lady and I think perhaps the other members of the panel as well, are having difficulty in hearing you. We've just asked for some technical assistance, so we'll wait for a moment, and you won't be prejudiced as to the time for your submissions.
Can you turn up your microphone volume?
Turn it up or down?
Up.
You're giving me a challenge here.
About the same, I think. We'll just wait. We'll just wait for a moment. David, you have difficulty. Mary, we're going to rise for a moment until this can be sorted out.
Thank you very much.
Mr. Mendes.
Thank you very much, my Lord. I'm not too sure how much of what I said you heard, so maybe it's best that
I think you might recap.
Yes,
you were taking the point about whether this particular issue had been raised before the judge or the Court of Appeal.
Yeah, well, you will see from the judgments of the first instance judge and the Court of Appeal that the rule in Turkwan's case was not dealt with at all.
Yeah.
And we are saying that that is because it was not pleaded. What was pleaded was that the maximum liability that had been set by the Commissioner applied only to borrowings, not to deposits. Therefore, the deposits were not to be taken into account in determining whether the maximum liability had been exceeded. That the other pleading was that it didn't go to capacity as such, and that there was an estoppel brought about by the fact that it had been represented to Mr. Shamsuddin, acting on behalf of the appellants, that the maximum liability had not been exceeded. So that was the pleading. The rule in Turkwan's case was not raised.
Well, whether or not it was raised specifically, issue 4 was whether if the loan was not within the maximum liability, that rendered it ultra vires and therefore void. So that was an issue, and that is the issue that we're arguing about, isn't it?
Yes. The learned friend is saying that the question whether the rule in Turkwan's case applies or not depends upon whether the breach that we are concerned with is an internal management matter or not. He seems to be saying that you determine whether it's a matter of capacity or a matter concerning the rule in Turkwan's case simply by asking the question, is this an internal management matter or not? We respectfully submit that that is not the correct approach. The correct approach would have to be to determine whether what the company did is something that it is constitutionally permitted to do. I'm using the broad term constitutionally because what it is permitted to do as a company can be determined by what it puts in its memorandum articles of association, what it lists in its objects in the case of a private company. Or it could be determined by what the law provides. In the case of a private company, there may be provisions in the Companies Act itself that says that there are certain things that the company as company cannot do. In the case of statutory corporations, that would be the clearest case where the statute would specify exactly what the company can do. And in the case of cooperative societies like the one that we are dealing with in this case, you also have to look to the Society Act under which the society is created. Regulations which govern it determine whether it has the capacity to do done. Not simply a matter of saying, is this an internal management matter or not? Is this a matter that you would expect to know about? It's simply a question of what the company was constitutionally. That is the point that is made in the Turkwan's case itself. You will see bundle at page 5. At page 5 might not be the clearest copy, so I think my learned friend has provided you with this copy in the Turk. At page 1885, which is page 479 of the report. First full paragraph on that page.
Which paragraph in the electronic bundle, please, Mr. Mendes?
It's electronic bundle 1885.
1885, thank you.
Yes.
Bear with me a moment, please. Yes, thank you.
And I'm reading from the first full paragraph on that page that reads, no illegality appears on the face of the bond or condition. Good P, therefore, must allege facts to establish illegality as was done in Collins against Blanton. This plea makes no charge of fraud against the plaintiffs and states no facts from which fraud can be inferred, shows no immorality nor breach of common law or statute law. That was the premise of what then flows as to it being unfair to require third party dealing with a company to know of the internal dealings of the company. premise is that we're not dealing with a question of capacity. Questions of capacity can arise if there's a breach of the common law or statute law. Now, this is what we say has happened in this case. There's a clear provision in the statute which governs or which establishes the constitution of the Hindu Credit Union. And the loan that was granted in this case was in excess of the maximum liability that the credit union was permitted to in law. Now, of course, there is ample authority for the fact that, or for the proposition that a breach of a statute goes to capacity. You will see that that is stated very clearly. The judgment of Justice Hobhouse, as he then was in the Credit Suisse case. I'll ask you to look at electronic bundle number, page number 138. This is just above letter E on that page.
I'm sorry, the electronic number again, please.
1328.
Thank you. Yes.
So Justice Hobhouse says, just above letter E, where a statutory corporation purports to enter into a contract which it is not empowered by the relevant statute to enter into, corporation lacks the capacity to make the supposed contract. Lack of capacity means that the document and the agreement it contains not have effect as a legal contract, exists in fact but not in law, it is a legal nullity. If the prohibited contract, which is in truth not a contract, does not confer any legal rights on either party, neither party can sue on it, so on. So it is clearly recognized in law that your legal capacity to do a certain thing can be determined by the statute. Put differently, it would be the oddest thing that a corporation that is established under a statute which governs its activities can be simply ignored. This is that, well, all depends upon whether the third party dealing with it knew that there was a breach or not. Cannot fix that person's knowledge. Free to the statute as we. Now, it is interesting that on the previous page of the judgment of Lord Justice Hobhouse, electronic bundle 137.
Mr. Mendes, I'm sorry, my lady and I are once again having great difficulty in hearing your submissions, and we're going to rise again, I'm afraid, and ask that something be done about this. Right. Thank you, Mr. Mendes. I'm very sorry we're having these difficulties.
My Lord, I apologize. Not too sure exactly what you heard, but I can try to make my points as quickly as possible so I can get to where I'm ultimately going. I read, first of all, from the Turquoise case, in which the point I was making was the premise of the application of the rule was that there had been no allegation of legality, such as a breach of the common law or breach of statute law. I was then making the point that is not the correct approach to determine whether a failure by the company to do something is a matter of capacity or not. Ask the question whether it is a matter of internal management or not. But the question that has to be asked is, what is the company constitutionally committed to? That question can only be answered by looking, in the case of private companies, to the memorandum and articles of association, but also to the Companies Act, in the event that there is a provision that prohibits the company from doing a particular thing, and in the relation to corporations such as the Hindu Credit Union, one would have to look at the legislation under which it is constituted, determine exactly what it is that it is permitted to do, what it is not permitted to do. That context that I referred your lordships and my lady to a passage from the judgment of Lord Justice Hobhouse in the Swiss case, electronic bundle number 138, just above letter E, Hobhouse, making the point where a statutory corporation purports to enter into a contract which is not, it is not empowered by the relevant statute to enter into, lacks capacity to make the supposed contract. This lack of capacity means that the document and the agreement is effect contract. So the question that has to be asked in this case, but with respect to my learned friend, he has not addressed exactly what it is that the legislation and the regulations in this case say about the Hindu credit union's capacity to enter in loan above a certain level, or at a point in time when minimum liability that has been fixed by the commissioner has been exceeded. What does the legislation say about that? Now, in that regard, it's important to recall, as pointed out by from Wilkinson in the Roll Steel case, I'll ask you to look at electronic page number 1873. This is just above, getting just above letter D, where he said the critical distinction is therefore acts done in excess of the capacity of the company, acts done in excess or abuse of the powers of the company on the other. Transaction is beyond the capacity of the company. Any event in nullity, void, whether or not the third party had notice of the invalidity. Transfer of money paid under such a transaction irrecoverable from third party. On the other hand, the transaction, or in excess or abuse of power, within the capacity of the position of the third party on whether or not the transaction was in excess or abuse of the powers of the company. The friend wishes to bring this case into the latter scenario, one where the transaction is within the capacity of the company, but there has been some use or excess of powers given, say, of course, in the Court of Appeal, and the first instance judge held in the court below. This went to the capacity of the HCU to grant a loan at all. Now, it is therefore imperative, respectfully submit, the legislation that governs the HCU be examined. In this regard, I would ask you to, first of all, at electronic bundle page number 1229, Section 17 of the Cooperative Societies Act.
Sorry, the page again, please.
1229.
Thank you.
And Section 17 says that the Commissioner may, on being satisfied that the Society has complied with the provisions of this Act and the regulations, that its proposed bylaws are not contrary to cooperative principles, approve the bylaws and register society. So that before a society is registered, an exercise has to be undertaken to determine whether the society is in compliance with the Act and the regulations, and to ensure that its bylaws are compliant as well. Only when that is done that the society is registered. Then you will see in section 22, which is at page 1230, that the Act provides that every society shall be constituted and managed in accordance with its bylaws and the regulation. A clear statement. The constitution of the society must be in accordance with its bylaws. And if I could also refer you to section 71 of the Act, you'll find it on page number 1250, provides that society or any officer or member thereof or any other person who fails without reasonable cause or willfully neglects to comply with any requirement of this Act or the regulations, furnish any information, or who purporting to comply with any such requirement, knowingly furnishes false information, is guilty of an offense. Goes to the point of making it an offense not to comply with regulations. The Act also deals with the question of the borrowing powers of a society. You see that in section 44, on number 1238. Section 44 says that subject to the regulations or any bylaws of a society made for the purpose, a society may receive deposits and loans from persons who are not members of the society for the purpose of meeting any of its obligations or discharging any of its functions under this Act. So here is the Act giving the Hindu Credit Union the power to receive loans, but that is made subject to the regulations. Of course, we now have to ask ourselves the question, well, what exactly do the regulations provide?
Mr. Mendes, Lord Stevens has a question for you. Lord Stevens has a question for you.
Yes, the HCU therefore has the capacity to borrow money, but that is subject to a limitation.
That's correct.
And so,
in other words, yes, but it does not have the capacity to borrow money above a certain level. Because you have to read section 44(1) together with the regulations, which say, and I'll take you to the regulation momentarily, it says that no society may receive loans above the maximum liability.
how does a lender know whether or not the HCU is borrowing in excess of its borrowing capacity?
They would make inquiries. Of course, the legislation itself puts them on inquiries. When you look at the regulation 14, it specifically says that may not borrow above a certain level. Then the person who wishes to transact with the Hindu Credit Union is required to make an inquiry. If they fail to make the inquiry, or if they do and they get the wrong answer, then what Chaplio says is that society is still not bound because the society lacks the capacity to contract with any third party above a certain level. In other words, section 44(1) has to be read as though the limitation on its borrowing powers is contained right there. It should be read as if a society may receive loans as long as maximum liability is not exceeded.
But isn't an alternative interpretation that the company has the capacity to borrow, but there's a rule that it must obey, or its directors must obey, which is not to borrow more than a particular amount? And if they disobey that rule, that's a breach of the regulations. but it doesn't mean that they didn't have capacity to borrow.
That may be subject to such an interpretation if the regulations solely limited the powers of the directors to borrow. The regulations do not only limit the powers of the directors to borrow. It says that the society shall not borrow above the maximum liability, which is a direct limitation on the society's capacity to enter into particular contracts. Of course, whether the society entering into that particular contract is something that the third party may be interested in knowing, but it really does not matter whether the third party knows or not, but as long as the society is acting outside of its capacity to borrow.
Well, couldn't the same argument be made that the society will be in breach of Section 71, and so it may be at risk of sanctions and have committed an offence, because I think Section 71 you showed us applies to the society if it breaches the regulation limit, but that doesn't go to what it has the capacity to do. It just is a regulatory breach and a criminal offence.
It comes back to the construction of Section 44. Section 44 is defining exactly what powers the society has in relation to the receiving of loans. It is saying that that power that is being granted here.
But in Section 44, do you say that any breach of any bylaw takes a matter outside the capacity of the society?
Not necessarily, no. But in this particular instance, the borrowing power a specific borrowing power is being granted. The borrowing power that is being granted is not an unlimited borrowing power. Society is not being permitted by law to borrow any amount of monies that it wishes to. It is being permitted to borrow up to a certain limit. The same way, for example, in Chapleo, there was a limit on the borrowing powers, and similarly to the case of Wenlock, where the statute had provided that you could borrow up to a certain limit. In both cases, the courts held that the liability of the corporation was not liable, could not be held bound by the contract.
How do you distinguish then page 1873, letters D to E, if on the other hand, the transaction, although in excess or abuse of powers, is within the capacity of the company?
I'm sorry, my lord, I think it's my turn now to say that I didn't hear you very clearly.
I do apologize.
Please to repeat.
Well, 1873, letters D to E, postulates the position of a transaction in excess or abuse of powers.
Yes.
And isn't this borrowing in excess or abuse of powers?
This is in excess of the corporation's capacity. The corporation is being constituted under a statute that is defining what it can and cannot do. One may describe it as it being given a power to do something, that is to say, a power to borrow. One may use the word power to describe exactly what it is being given. But nevertheless, the organization is governed by the statute, and this is the statute that is defining what it can and cannot do. The statute says that it is against the law for you to do this particular thing. The question is, having done it, what is the consequence of it? And what the authorities indicate, I've just read to you the passage from Judgment of Lord Justice Hobhouse in the Credit Suisse case, is that if you enter into a contract that is prohibited by statute, then it is null and void. It is not a simple case of exercising a power incidental to objects of of the company as set out in the Memorandum and Articles of Association. It is the statute defining exactly what it is that the company can do. Statute itself, in other words, comprises the constitution of the company, defines its existence. We cannot decide that I am going to contract out of the statute itself, enter into contracts that are written by law.
But on the face of it, there's a distinction between things which the company is capable of doing, or the society is capable of doing, and things which it is capable of doing, but it must not do because it's forbidden by law from doing them. And it looks to me, just from the drafting, as though Regulation 14 is not a limit on what the company is capable of doing. It's just a rule which it is required by law to comply with in doing what it is capable of doing.
My Lord, if we can look at the wording of Regulation 14 itself, you will find that at electronic bundle page number 1260, going over to 1261. And 14.1 says, first of all, every society shall from time to time fix at a general meeting the maximum liability it may incur in respect of loans or deposits, whether from members or non-members. Then 14.2 says the maximum liability fixed under sub-regulation 1 shall be subject to the approval of the commissioner, who may at any time reduce it. And then sub 3 says, no society shall receive loans in excess of the maximum liability approved or fixed by the commissioner. Now it uses the same language as is used in section 44 of the Act. And you will have noted that in the side note to section 44, it refers to Act number 24 of 1976. These regulations were made in 1971. So but the language it reflects the language that is used in section 44.1. So while section 44.1 says society may receive loans from persons who are not members, Regulation 14.3 says no society shall receive loans in excess of the maximum liability. So this is defining what its power is. It's a jurisdictional issue if you put it in terms of administrative law. It's saying what the society does not have jurisdiction to do. As long as that maximum liability is exceeded, does not have jurisdiction to enter into this particular contract. Not simply a matter of doing something that it was authorized in law to do, exceeded its powers, is not authorized in law to do this at all. Therefore, it goes to capacity, not a question of simply excessive power. In this regard, if I may draw your attention to something that Lord Justice Slade had said.
Mr. Mendes.
One moment, Mr. Mendes, please. Sorry. Lord Stevens has a question.
So, section 44 at page 1238, do you then have to, does a person lending money to the society have to inquire about its obligations and functions?
They ought to do so, but if this goes to capacity, it really doesn't matter whether they do so or not. Question of knowledge on the part of the third party is really irrelevant. It would be the same where a company is set up under its objects to do particular things, and then it is doing something that is not to be found in its objects at all. It lacks capacity. The third party who is dealing with the company will similarly be required to look at the memorandum and articles to determine whether the company has the capacity to do the thing. It would be wise of them to do that. But whether they do it or not has no consequence in law if it goes to the capacity of the company. We're respectfully submitting that this goes to the capacity of the company. And therefore, the wise thing for Mr. Shamsuddin to have done, which he did do, was to make a request for information concerning the maximum liability, because he understood that he understood the limitations of the Hindu Credit Union to enter into loan transactions.
Well,
This is why he made inquiries as to the maximum
of whom
liability.
should the request be made? Of whom should the request be made, Mr. Mendes?
The request should be made of the company, but I would imagine that it would be even a better course to make a request of the commissioner. And in this particular instance, Mr. Shamsuddin was provided with the letter of approval of June 2004.
But it applies as well to depositors who are not members.
Our next question.
So if you're a depositor who is not a member, are you expected to write to the commissioner before you deposit money with the society in order to check that it hasn't exceeded its limit?
I'm not saying that you have to do it. I'm saying that it would have been the wiser course, particularly in this instance where you...
Is it realistic to interpret the legislation as creating that hazard for depositors?
The hazard being...
The hazard being that if you haven't asked the commissioner before you deposit money with the society about its limit and then found out, presumably from the society itself, what its actual level of deposits is at the current time, you take the risk that your deposit will be a void contract.
My lord, if it goes to the credit union's capacity, then it does not matter whether an inquiry is made, whether of the company itself or of the commissioner. It's irrelevant. If it is contrary to the society's constitution, then the transaction is null and void.
Well, I understand you're making... I understand the point you're making, but it follows that the same rule applies for a depositor.
Yes, it does. We are accepting that it applies for depositors as well. And I'm saying that in those circumstances, having regard to what Section 44 provides and what Regulation 14.3 provides, it is a wise course of action to make an inquiry. But I'm saying the failure to make an inquiry in these circumstances does not matter if it goes to capacity. I was going to refer you to a passage from the judgment of Lord Justice Slade.
Mr. Mendes, forgive us. There's another question from Lord Stevens.
I do apologise, and I didn't.
Very sorry.
I'm sorry, Mr. Mendes. Could I bring you back to Section 44 and meeting obligations or discharging any of its functions? Are you saying that if that the person who lends money must also make inquiries about obligations and functions, as well as the limit on lending, borrowing capacity?
You mean whether they have to make inquiries as to deposits and other loans?
No. Section 44 enables the society to receive loans for the purpose of meeting any of its obligations or discharging any of its functions under this Act.
Yes.
Does a person who wants to make a loan to the society have to then make inquiries about its obligations and functions?
What it needs to make inquiries about, because Regulation 3 limits the capacity of the society to receive deposits and loans, would have to make inquiries about deposits and loans, not all of the obligations of the society. Regulation 14.3 is limited only to deposits, loans. And this is in context, of course, where the society has to publish its annual account. So this is information that should be readily available. But in that context, my lord, if I may, take you to a passage from the judgment of Lord Justice Slade in the Royal Steel case.
Page, please. Electronic one.
1864.
Thank you.
And you will see that he sets out his conclusions on the authorities. And at letter B, he says the basic rule is that a company incorporated in a Companies Act only has the capacity to do those acts fall within its objects as set out in its memorandum of association, or reasonably incidental to the attainment or pursuit of those objects. And then he says in second paragraph, nevertheless, if a particular act, such as each of the transactions in the present case, is of a category which, on true construction of the company's memorandum, is capable of being performed as reasonably incidental, the attainment or pursuit of its objects, it will not be rendered ultra vires the company merely because, in a particular instance, its directors in performing the act in its name are in truth doing so for purposes other than those set out in its memorandum. Then he goes on to make the point in the third paragraph, where the particular power falls, whether it is a matter of capacity, simply something incidental to the objects of the company, depends upon proper construction of the power. But he says this, while due regard must be paid to any express conditions attached to or limitations on powers contained in a memorandum, example, only up to a specified amount, will not ordinarily construe the statement in a memorandum that a particular power is exercisable for the company as a condition limiting the corporate capacity to exercise the power. It seems that Lord Justice Slade is accepting the possibility, of course he doesn't say so definitively, he's accepting the possibility that the power to borrow money only up to a specified amount is a limitation on a power that goes to capacity. It's not just an internal memorandum, so an internal organization issue. If I can also direct your attention to Lord Justice Brown Wilkinson said in the same case, this is a paragraph at electronic page number 1874. And this is at letter D. He says, if on construction of the objects clause, the transactions fall within the objects as opposed to the powers, will not be ultra vires since the company has the capacity to enter into the transaction. Then he goes on, if the objects clause contains provisions, whether objects or powers, show that a transaction of the kind in question is within the capacity of the company, that transaction will not be ultra vires. Sometimes the drafting of the memorandum and articles may be such that they put third parties on notice of the fact that certain things can only properly be done subject to certain conditions being satisfied. Third party is put on notice in this way, he will not be able to rely on any exercise of the power which he knew discovered did not comply with such conditions. So that seems that Lord Justice Brown Wilkinson was pointing to a halfway house in circumstances where a power is expressed in a certain way, subject to certain conditions. So that to answer the question that was being posed to me earlier, is it that you will expect a depositor who is approaching a cooperative society must make inquiries as to whether the maximum liability has been exceeded? Answer which respectfully is yes, because the depositor is put on notice by the way in which the power has been expressed. Now,
well, the difficulty I have, if I could just come back to it once more, is how the power is, what you say as the power is expressed. If the relevant regulation had said no society shall have the power to receive loans or deposits in excess of the maximum liability, then I would entirely see your point. But it doesn't say no society shall have the power. It says no society shall do this. And that looks to me like a rule that it's expected to obey, not a restriction of its powers.
My Lord, I would respectfully beg to differ. As I said, the language that is used in Regulation 14.3, that Section 44 of the Act is made subject to, is that the society shall not receive loans. It says no society shall receive loans. A society shall not receive loans in excess of the maximum liability. And that is to be read alongside Section 44, which is saying a society is permitted, if I may use the exact language, a society may receive loans. So one section is saying the society may receive loans, so it's being permitted to receive loans, it's being given the power to receive loans, but that power is immediately cut down or limited, circumscribed by Regulation 14.3. It says that this power that you have to receive loans is not exercisable by you if the maximum liability is going to be exceeded.
Well, the problem with that argument is it proves too much, because the words in Section 44 are subject to the regulations and bylaws. And if you're going to say that they restrict the powers, then it seems to mean that every time there's a breach of the regulations or the bylaws, you're outside the capacity of the company, which surely can't be the intention.
But, my Lord, I would think that you would have to read it when it says subject to the regulation and the bylaws. I think you'd have to read it as you'd have to read the bylaws and the regulations together with Section 44. There will be some things in the bylaws or in the regulations that says this is the procedure to be followed if you are going to receive a loan. For example, I'm just saying something at the top of my head. That would be something that goes towards internal management. If what is followed is you didn't exceed the maximum liability, but what you did is you didn't follow the procedure set out under the bylaws.
So then you have to construe each regulation or bylaw and see which category it comes into. And that brings us back to Regulation 14 and what it means.
Precisely, my Lord. And we say that having regard to the fact that Regulation 14.3 is a regulation that is defining the contours of the power that is vested in the society by Section 44.1, that Regulation 14.3 goes to capacity. It is not dealing with the procedure to be followed in the exercising of the power to receive a loan. It's not saying what the directors must be satisfied of before they make a decision to receive a loan. It doesn't say what meetings must be held, etc., etc. It is talking about the actual power that the society has. And it could be expressed in a number of different ways. This is as it has been expressed, for example, in Chapley or in the Wenlock case. You do not have the power to incur a loan above a certain amount of money. And that's it. If you go above that money, you have violated the statute. And the consequence of that is that the contract is null and void.
What happens if the limit is exceeded at a later point as a result of a further loan made?
The further loan, my lord, would be affected, but the previous loan, which when it was granted, the maximum liability had not been exceeded. The fact that the maximum liability is subsequently exceeded by another loan, that cannot affect it.
How about a loan? How about a loan that partly was within the limits and partly outside the limits?
Then, as in I think it was in the Wenlock case, what the company did in those circumstances was to accept liability up to the maximum. And it says, and that's what the court in fact ordered. Court of Appeal ordered it, and it was upheld by the House of Lords in the Wenlock case, that the company was liable up to the £25,000 limit. And I think the loan in that case was about £173,000. The House of Lords held that the loan above the £25,000 pound amount was not enforceable against the company.
Could you just help me, please, how this interrelates with 29, which is on page 1264?
Yes, my lord. This is that is a 1264. This is simply says that the board may borrow money on behalf of the society to an amount not exceeding the maximum. So it is empowering the board, I imagine, to exercise the power that the society is given. But of course, it has to be in accordance with Regulation 14.
So in your submission, this is simply ancillary to 14, and
it is saying yes. It's saying how the society's power is to be exercised. It is to be exercised by the board, but it's making it clear that it is subject to it would have to be not exceeding the maximum liability.
But this in a sense confers a power on the board, which may not be properly implemented in a particular case, but that would be a restriction on or limitation on the exercise of a power, as opposed to affecting capacity, were capacity to exist. Is that right?
That is correct. That is correct, my lord.
But your fundamental point is you never get there because...
I'm sorry.
Your fundamental point is you never get there because 14, in this case, is putting a limit on capacity.
That is correct, my lord. And it addresses the capacity of the society. It says 14.3 says no society shall receive. And in that regard, just for completeness, if I may point out, the learned friend in his written submissions refers to the bylaws at page electronic bundle page number 0573. And that's bylaw 49. 49A says that the board may borrow money on behalf of the society to an amount not exceeding the maximum liability, which is a repeat of Regulation 29. And then 49B says the society may borrow loans from persons who are not members for the purpose of meeting any of its obligations. And he is, again, that appears to be giving the society an unlimited power. But when you look at Rule 1B of the bylaws, which is at electronic bundle page number 0552, says that these bylaws are supplementary to the provisions of the Act and the regulations, and the society shall be guided by the Act, the regulations, and the bylaws read together. Of course, that provision is not necessary because the bylaws in any event would have to be read subject to the regulations. Bylaws cannot change the regulations. Bylaws cannot give the society a power, an unlimited power to borrow, when the power to borrow that is vested in the society is in fact limited by the regulation. That's just my learned friend had relied on those provisions without making a reference to how it is affected by Regulation 14.3 of these regulations. So our case is that this is a capacity case. Capacity of the society is limited by the statute and the regulations. But in any event, if my learned friend is permitted, despite the fact that the Turkwan rule was not pleaded, or they not consider this at all, he is permitted to raise it, then we respectfully submit that he cannot rely upon it because he did have notice of the maximum liability, as the evidence has indicated very clearly. If I may just direct your attention very quickly to the authority that my learned friend cited of Morris against Canson, decision of the House of Lords, electronic bundle 1580.
The reference again, please.
Electronic bundle page number 1580.
Thank you.
And just towards the middle of that page, this is judgment of Lord Simons, he says one of the fundamental maxims of the law is the maxim omnia presumpto rete esse acta. As many applications in the law of agency, it is illustrated by the doctrine of ostensible authority. The law relating to corporations, this application is very similar. Wheels of business will not go smoothly round unless it be assumed that it is in order, which appears to be in order. The maxim has its proper limits. Ostensible agent cannot bind his principal to do that which the principal cannot lawfully do. We respectfully say that is this case. Directors or acting directors or other officers of a company cannot bind it to a transaction which is ultra vires, what we say the case is here. Nor is this the only limit to its application. It is a rule designed for the protection of those who are entitled to assume just because they cannot know that the person with whom they deal has the authority which he claims. It is clearly shown by the fact that the rules cannot be invoked. The condition is no longer satisfied. That is, if he who would invoke it is put upon his inquiry. He cannot presume in his own favor that things are rightly done. The inquiry that he would make would tell him that they were wrongly done. Now, but I referred you to a passage of Lord Hobhouse in the Roll Steel case. Sorry, Lord Justice Slade, in which he was making the point, or may be expressed in a that it is subject to a condition, in that you are put on notice to make an inquiry as to whether that condition was met. In this particular case, Mr. Shamsuddin, an attorney at law, acting on behalf of the appellant in this case, made inquiries, says that he knew about the regulations, he knew about the maximum liability, so he made inquiries. See, in his witness statement, you'll find at electronic page number 0540. This is in paragraph 2 of his witness statement. He said, about 2004, the defendant was requested to make advances from time to time up to $1,500 US to the Hindu credit. Sorry, 1.5 million, I'm sorry. This was made to me acting for the defendant, who was made by Mr. Harry Harnarayan, acting for the HCU. In support of its loan request, the HCU provided the defendant with copies of the minutes of its special general meeting held on April 17, 2004. A letter to the HCU from the Commissioner of Co-Operative Development dated January 25, 2004, granting approval for the increase of its maximum liability to 100 million. Attaches the copies of the minutes and the letter. Also spoke to Mr. Harnarayan and Mr. Ramnath, the then Secretary of the HCU, to confirm the accuracy of the contents of these letters. I was at the time advised by Mr. Harnarayan and Mr. Ramnath that the amount borrowed from third parties was under 60 million, that the proposed borrowings from the defendant would be within that limit. Now, it would be important, therefore, to look at what the documents Mr. Shamsuddin is referring to in that paragraph actually said. Minutes that he is referring to of the 17th of April 2004, you'll find that electronic bundle page number 1015 over to 1016. The letter of the 25th of June is to be found at electronic page number 1019. And minutes at 1015 says, last paragraph, Chairman, after identifying the various financial investments of the Hindu Credit Union Society and given the growth of depositors necessary for the Hindu Credit Union Cooperative Society to have the approval of the Commissioner of Cooperatives, thereby having the need to increase its liability by $100 million to cover these deposits stroke shareholders fund. So this increase in liabilities needed to cover borrowings and other credit facilities. And then on the page over, motion was moved by Mr. Ganga Bagwandeen, seconded by Mr. Paul Phillip. Liability of the Hindu is to 100 million to facilitate the expansion of the organization. And then the letter of the June 25th, 2004 at 1019 says, to inform you that a liability in the sum of $100 million is granted to the regulation 14.2. This, I wish to draw to your attention the provision of subsection 3 regulation 14 stipulates society shall receive loans or deposits in excess of the maximum liability by the commissioner. So his attention is drawn to section 14.3. His attention is drawn to the maximum liability. And in cross-examination, and my lords, my lady, of course, I don't have time to take you through the cross-examination, but you will see electronic bundle from page number 0265.
Sorry, which page?
0265.
Thank you.
Through to 0291. Mr. Shamsuddin is cross-examined at length about what he knew. What he was maintaining was that in his view, regulation 14 only applied to borrowings, not to deposits, despite the fact that it says deposits. His view was it applies to borrowings, and as far as, and he also says in the cross-examination that he had the accounts and he examined the account. He appreciated that the deposits would have been in excess of 100 million, that the borrowings were not in excess of 100 million. So it is on that basis that he satisfied himself that it was that the maximum liability would not be exceeded. But he was wrong, and was also acting, he says, on the basis of the representations that he had been made to him by Mr. Harnarain. It is in that regard that it is important to recall what Lord Justice Bagaley had said in the Chaplio case. My little friend read you the passages earlier on. But it's important to recall, this is electronic page number 1211, top of the page, page 713 of the report. The plaintiffs and everyone else who have dealings with the building society are bound to know that such society has no power of borrowing except such as is conferred upon it by its rules. If in dealing with such a society they neglect or fail to ascertain whether it has the power of borrowing or whether any limited power it may have has been exceeded, they must take the consequences of their carelessness. Maybe that the plaintiffs in the present case have been misled, representations of conduct of others, into the belief that the company had full authority to accept the loan from them. That is a question which I shall have to consider when dealing with the other appeal. Such representations of conduct may doubtless give rise to a claim against the parties taking such misrepresentations or so conducting themselves. But in my opinion, they can in no way give rise to or support a claim against the society. The point is that the regulations themselves put Mr. Shamsuddin on inquiry. And that inquiry, as we have sought to establish in detail in our written submissions, but I don't think I have time to take you through, that inquiry led him to the conclusion the maximum liability of $100 million that was being set was not limited, as he led himself to believe, borrowings only, to deposits and borrowings, and at the time that at the time that the loan was granted, the loan to the society, the $100 million limit had been exceeded by deposits. In that regard, my lord, if I may just spend a little time on that question, because I think it is important to see exactly what the maximum liability was dealing with. Let me take you first of all to the increase in the liability to $50 million, which occurred in 2002. I'll ask you to look at electronic bundle page number 0971. This is the request from the Hindu Credit Union dated the 20th of August 2002. They say, hereby seek your permission to increase the liability of the Hindu Credit Union from 20 million to 50 million. This request is keeping with the decision made at the special general meeting on the 20th of July. Then they write again on the 5th of September 2002, electronic bundle page number 0972. They say, with reference to our letter of the 20th of August, requesting an increase in the liability from 20 to 50 million, further to discussions regarding the above, wish to submit the following reasons for this request. I could take you to paragraph 2. The credit union is now attracting multi-million-dollar deposits that are increasing with time. This increase in liability is also to meet any sudden demand by depositors for return of their investments. Then, a letter dated September the 10th, 2002, the Commissioner approves the increase in the maximum liability to 50 million, and you'll see that at electronic 0973. So by the time we come to the request for the increase, 50 million to 100 million in 2004, clear evidence is 50 million maximum liability was granted in respect of deposits. Certainly that was the request that was made. That is what the society in general meeting agreed to ask the Commissioner to approve. Then when you get to the 2004 sequence of events, I've referred you to the minutes of the meeting of the 17th of April already. Then you have a letter dated the 19th of April 2004, which is at electronic bundle page number 1017.
Sorry to interrupt you, but can I just understand how this issue arises? What do you say the position? If you're right that the transactions were ultra vires, I think it's accepted by the appellant that that's the end of their, well, subject to their other arguments, that's the end of their case. If it's not ultra vires, supposing that we were against you and we interpreted the rules as not setting a limit on the powers, what is, how does this question of notice arise in that context?
Because the learned friend is relying on the Turkwan case to say that he cannot be affected by some failure on the part of the company to comply with some internal management requirement, unless he knew of it, unless he was put on inquiry.
Are all these issues, have they been in play up to now, or is, I just would, your case was we don't owe you any money because it's ultra vires. Do you have an alternative case that's been going that if it's not ultra vires, we still don't owe you any money because you were aware of the restriction on the director's powers?
No, my lord, we did not get to that because the Turkwan case was not pleaded. Therefore,
no, but it's not a question of Turkwan being pleaded. As I understand it, you have to show that the transaction is invalid, and you do that by saying it's ultra vires. But what if you're wrong? Do you have an alternative case that it's invalid for an alternative reason?
Well, it is invalid, my lord. We say as well because it is illegal on the basis of principles of illegality. But we say as well that if my learned friend now wishes to say that this didn't go to capacity, and therefore, even though it was in breach of the regulation and therefore illegal in breach of the regulation, you cannot, I am still entitled to enforce it because I did not know of the breach. In other words, he's relying on the Turkwan case. We are respectfully submitting that that ought to have been pleaded. So this is in direct answer to my lord's question. Why am I talking about notice? I'm talking about notice because my learned friend began his submissions today by saying that the major flaw in the Court of Appeals judgment was that they gave no consideration to the applicability of the Turkwan's case.
I'm sorry,
we say that it's not open to him because it wasn't pleaded, And you will see, my Lord, in Lord Justice Slade's judgment in the Roll Steel case at electronic bundle 1854, he says, just at letter C, in my opinion, however, it was at the very least incumbent on the defendants, if they wish to take the point, in the alternative that even if, which they denied, resolution of the 22nd had not been duly passed, they did not know of this irregularity, were entitled to rely on it as one which had been duly passed. This would have been a conventional plea by way of confession and avoidance, should have put the plaintiff's legal advisors on notice that they had to adduce evidence, if they could, to show actual or constructive knowledge of the relevant facts on the part of the Colville and British Steel Corporation or their legal advisors, and to explore these matters so far as possible in cross-examination of the defendant's witnesses. What was put before the court was not this plea of confession of avoidance, raising the Turquoise case, because it was not argued at all in the court below. What was argued was estoppel. The estoppel was that I had representations had been made to me about whether the maximum liability had been exceeded or not. Therefore, you can't go back on that now. The cross-examination that I have referred you to was cross-examination on the question of estoppel. What I'm saying, my Lord, is that if my learned friend is allowed to say in the alternative that he falls within the Turquoise rule, then our response to that is, of course, it's a response in the alternative. My Lords do not agree with our case that this is a capacity case and the society acted outside of its capacity, then we say the Turquoise case is not applicable because the appellant was put on notice and indeed had all the information that would have led Mr. Shamsuddin to the conclusion that the maximum liability had been exceeded. So I'm pointing out to you what the evidence indicates about the maximum liability having been exceeded. That was information that he had in his possession. He drew, respectfully submit, wrong and irrational conclusions as to what the maximum liability applied to.
Mr. Mendes.
In answer to the friend, we are entitled to say at this stage that, that his client had notice or was put on inquiry.
Mr. Mendes, Lord Stevens has a question.
Sorry.
Yes, my Lord.
The test would then be actual knowledge or constructive knowledge.
That is correct, my Lord.
My difficulty following that argument is that the amount of deposits at the time were 860 million. And nobody seems to have understood, had constructive knowledge, that that was in excess of a limit of 100 million. So I'm uncertain as to how the HCU, or the liquidator of the HCU, or indeed the commissioner, can blame somebody else for not appreciating these limits when they themselves didn't do so.
Well, my Lord, that is why there was a commission of inquiry to find out exactly what happened, why the HCU collapsed. That is why I would imagine that the government of Trinidad and Tobago made the decision to bail out the depositors, because obviously the regulator wasn't regulating. It is to say the least, and of course this is an understatement, odd that the commissioner would be approving an increase to $100 million, which had already been exceeded, because the deposits were far in excess of $100 million. But to the third party who was deciding whether to borrow, the fact of the matter is that because the limit had been exceeded, the society had no capacity to enter into the transaction. Or if it is not a question of capacity, then the information was there. It was glaring that the maximum liability had been exceeded. Mr. Shamsuddin did his investigations, and if he didn't have actual knowledge, then he is willfully blind to the fact that there was a maximum liability, that the commissioner said in the letter of the 25th of June 2004, the society could not exceed either by way of deposits or loans. That is stated clearly in the letter that he had in his possession. He was willfully blind, therefore, to the fact that society would be breaching Regulation 14.3 if it took this loan from him.
But you don't expect the commissioner to write a letter like that if the commissioner knows that the society is way over its maximum limit. It's not the kind of letter that you send as the commissioner.
Absolutely, my lord, and that is, but it was done over and over. All of the letters that we have referred you to from since the year 2000, starting with the maximum liability of 650,000, going to 3.5, to 20, to 50, to 100. On each occasion, when the maximum liability was increased, the deposits were in excess of the amount. As I said, that is why we had a commission of inquiry. But the fact of the matter is that when this loan was granted, regulation could not have been granted otherwise than in breach of Regulation 14.3. That is just a fact. And the question is, what is the legal consequence?
May I ask this?
I'm sorry.
If you'd be kind enough just to go to page 405 of the bundle, of the electronic bundle.
I have to ask my Ms. Daft to assist me with that, my lord. Let me have 1 minute, please, madam.
Paragraph 10, the Court of Appeal summarised it's an aspect of their summary, and in paragraph 10, subparagraph B and C, there's a summary of the findings that they're making based on the findings of the judge at first instance, which, as I understand it, they're not interfering with.
That's correct, my lord.
And you rely on those findings?
Absolutely, my lord. I'm grateful to you for reminding me of that.
And could you please just point us to the substantive paragraphs in the judgment of the Court of Appeal and at first instance on which you say that summary is based? And whether you rely on those?
Could I ask, I'm not going to be able to do that right away, my lord, and I'll ask Mr. Daft, who's sitting here with me, to get those paragraphs, and if maybe I can either, before the hearing is over today, give you those references, or alternatively in writing subsequently. Is that okay, my lord?
That's fine.
That would be perfectly fine for me if that's
Yes. Thank you, Mr. Mendes. We'd be grateful if you could supply that in due course.
Thank you very much. So in essence, that is,
Mr. Mendes,
our answer to
Mr. Mendes, my Lady Arden has a question.
I just wanted to ask you this to try and pull it together. In the case of a registered company, then if it has power to borrow, that power to borrow is by implication for the purpose of its objects. Unless it has an object of borrowing money, which isn't usual. But so it has to borrow for the purpose of its objects. It is the case, isn't it, that the courts mitigated the ultra vires doctrine for those registered companies where the lender to the company wasn't on notice that in fact the borrowing was for an ultra vires purpose outside its memorandum. That would be so, wouldn't it?
Yes, my lord. Definitely, that would be the result of the Roll Steel case.
Of Roll Steel, but
yes, and so they said that was not a capacity. It was not a question of capacity. You had the power to do it, but you didn't have the power to do it for purposes other than your objects. But in that case, the transaction was held to be null and void in any event because the third party had knowledge of the improper purpose.
Indeed. Obviously, if the banker or lender has knowledge that the money is borrowed for ultra-vires purpose, this particular mitigation of ultra-vires won't apply. But that was devised by the judges for registered companies. It was devised by judges for registered companies. But obviously the courts can't alter legislation. And if capacity is laid down with legislative authority, the position has to be different, isn't it? So we're in a rather special situation, if you're right about capacity. It isn't the normal situation that arises with a registered company.
Yes, my lady, that would be our respectful submission.
And Section 14 on your case deals exclusively with capacity, and there is no mitigation of it.
That would be our respectful submission, my lady.
Thank you.
Mr. Mendes, I know there have been interruptions in your address to us, but you're going to have to start to wind up now.
I was in fact winding up, my lord, to indicate that those are my respectful answers to my learned friend's case as he is presented today. Of course, we rely on our written submissions as well.
Thank you.
If there's any other question that I can answer, my lord, I will be pleased to do so. Subject to the additional information that I provide later, those are my respectful submissions.
Thank you very much. We're grateful to you. And I apologise again for the interruptions to your presentation. Mr. Flynn.
I think I can be very brief. Could I take the panel to page 404 of the bundle, please? This is the judgment of the Court of Appeal below. And starting at the top of the page, the court has there set out what the issues were before the Court of Appeal. You don't need to look at one. The issues I want to draw the panel's attention to are two: whether the society's capacity to borrow was unfettered, or if the loan was not within the maximum liability permitted under the Act and regulations, whether that rendered the loan ultra vires, and 5, if the loan was ultra vires, whether the security therefore was rendered void and unenforceable. Now, those issues raise squarely the question of capacity. And in order to answer the question of capacity, it is necessary to analyse, in my submission, the common law rules, including the decision in rolled steel, which you've already seen, and the analysis in rolled steel deals with the rule in Turcoman's case, because they're part and parcel of the same point. Now, it is true that the Court of Appeal do not mention Turcoman's case, and that is because they do an analysis of the statutory regime and say conclude there is no capacity. Now, in my submission, that doesn't mean that the issue is not in play. It is plainly in play. It's just simply that the judgment didn't deal with the submissions that I have put before the panel. Whilst we're here, I should just mention the question that the panel raised in relation to paragraph 10 at 405, because I hope that we will be given permission to respond to anything that is said in terms of the findings below. But it will be obvious in my submission that the findings in paragraph 10, or rather the setting out of the case in paragraph 10, only go to external matters. They do not go to internal matters. There is no cross appeal. If I am right and the panel accepts my submissions about capacity, in other words, this is not a case of capacity, this is not a case of ultra vires, this is a question of power when properly analysed, paragraph 10 does not assist because those are external matters, they are not the internal matters. And there is no cross appeal. There is no cross appeal that if the appellant is right that the Court of Appeal below are wrong on capacity, that there was notice, which is why I said at the beginning of my submissions, there is no case on notice here in the sense that my clients are said to have known of the internal matters, namely that there was a breach of the particular requirements, as opposed to knowing what those external requirements were. So in my submission, that argument won't take them anywhere, whatever they may say about the judgment below, because paragraph 10 won't help them, and nothing said below will, and there's no cross appeal.
Mr. Flynn, but But
Sorry,
the argument would still, the point that the qualification to ultra vires that you seek, which I referred to below as, referred to a moment ago as mitigation, there is, and I'm not rooting that necessarily in Turquin's case, if that mitigation exists, there is an argument as to whether it applies only to registered companies.
Yes, and the answer, my lady, to that is, I hope I've made my position clear, is what is the principled answer to that question? What the Court of Appeals say in their judgment is, they apply the statute and they say, all the rolled steel analysis, the rule in Turquoise, they simply don't deal with it. They simply say, applying Chaplio and Aladale, this doesn't apply in this situation. Now, in my submission, that raises acutely the question of, well, if that's the case, why not? What is the principal difference here? In a case of this kind, where the credit union's purpose is to lend and borrow money, if there's a limitation on the maximum liability, why should that affect capacity as opposed to its powers and have the consequence of the breach of those powers? That is a question, I agree, that is raised, not squarely by the respondent, but that issue is raised.
All right,
but in my submission, there is no principal difference between the two.
But now, suppose that the answer were that Section 14, particularly subsection 3, imposed a limit on the capacity. Would you still say it was open to the courts to apply a mitigation or whatever, where the lender did not know?
My answer to that is what we put in our written case, which is you have to look at the totality of the regime, first of all. So you have to, I won't take you to all of, but we put it in our written submissions: Regulation 29, Bylaw 49, Bylaw 3B5, Bylaw 31. We say that the proper reading of 14.3 in its context actually takes the matter no further. It is still a question of power, not capacity. It's still an issue. This is something that the Hindu Credit Union had the capacity to do, but it didn't have the power to exceed the maximum liability. And it's a question of that analysis. We submit that 14.3 doesn't provide any really greater answer than 14.1, actually.
But is that a matter of construction of 14.3, or is it because you say that even if 14.3 is in terms of a power, that it isn't effective to set a limit on capacity?
Both, I would submit. And I think it is a question of construction, though, especially by looking at also the other regulations to see the whole thing in context. Because you'll see in our written case, we set out why we say there were limitations on the board as opposed to the Hindu Credit Union. And one has to go through that quite carefully. As I say, Regulation 29, Bylaw 49, and Bylaw 3B5 and Bylaw 31. We've set those out in detail in our written submissions. But the bottom line here is that these are all matters of power, not capacity.
But doesn't that depend on what it actually means? So
yes,
I find
it does.
I can't understand how, if Regulation 14.3 or the statute says, suppose it had said in terms, the society shall not have power to borrow more than the maximum, or not have capacity to borrow more than the maximum limit, that would be the end of your case, wouldn't it? It all comes back to what it actually means.
It does, my lord, as in usual in cases of this kind. Your lordship is right. But when one looks at the analysis in rolled steel and turquoise and so on, one sees that the ultra vires doctrine, properly understood, is directed to matters that are not, which a corporate or entity is not capable of doing. And a limitation, an internal limitation, does not, properly understood, go to the capacity. It only goes to power. It has consequences, but it's not a capacity issue. Because if that were the case, you'd have these very problems that we've identified, which are, what is the outsider supposed to do in those circumstances?
I was going to say quickly that I'm grateful for my lord, that's not a problem. That's telling you where the risk of non-observance of the limit will fall.
Well, your ladyship is quite right, but the question that arises in practice is this. What is the person who's making a deposit in the Hindu Credit Union in Trinidad to do, and why should that person be at risk of having a void transaction, when in fact the answer to the difficulty in my submission is to follow the reasoning in rolled steel and Turkwand and to say this is not a matter of capacity.
Well, in the
sorry, my lady.
And I was going to say, in the modern environment, legislators provide for regulatory protection for small depositors. They obviously don't for big lenders, but that's the answer to that one, isn't it? In fact, if anything, the existence of the regulatory scheme rather confirms that depositors might be at risk, though principally, of course, they're at risk from insolvency.
I would respectfully disagree in that my submission would be that a depositor would not be sufficiently protected by that regime and should not be placed in that situation. Now, Lord Leggett has posited to me two things. One is, isn't it a question of construction, to which I agree? And if it had had very clear language that said in terms that there was no capacity, then I think I would have to accept that. If the statute said such in terms, in other words, it was effectively grappling with the issues that are before the panel and coming to the conclusion there's no capacity. Now, in my submission, that would be a very surprising thing indeed, but I think as a matter of principle, I would have to accept that if it said so in those terms, then so be it. And then it wouldn't cut across Turkwand's or rolled steel analysis. It would simply be that the outsider is taken to know that extreme position. But it's not the same as this case, because that is completely, in my submission, contrary to the common law rules in rolled steel and Turkwand's. It's completely the other way around. So in my submission, I understand that it might be said that there's protection for depositors from some ordinarily quite limited protection of depositors up to a certain level. But in my submission, that doesn't mean that it follows that the statute is intended to have these really quite dramatic consequences. And as I say, there are only really two authorities which have put in support of this, Chapleo and Allerdale, and they really don't come close to this, not close at all. In a sense, I think I'd be repeating my submissions if I went back to that. What I do want to make clear is a couple of points on procedure, and that is, it's said against me that this point isn't open to me, but I won't take you to it, but we do deal with it in detail in our case at E109, and the respondents deal with it in their case at page 147. So Turkwand's is fully in play. One thing I should make clear as well is this, is I believe it was said that Turkwand's was not before the Court of Appeal. Now, we have tried to limit what has been put before the panel to relevant matters. What you don't have are either my client's submissions before the Court of Appeal or the liquidator's submissions, but I've been emailed those and we can provide them to the panel. And they do raise Turkwand's case, not simply in our submissions, not simply as a matter of being in rolled steel, because rolled steel obviously deals with Turkwand's, and that is a critical case on the analysis of capacity. But they're actually also dealt with in the liquidator submission. So this issue was firmly before the Court of Appeal. What happened was the Court of Appeal simply rejected it on the basis of a statutory analysis and didn't mention it, presumably on the basis that it didn't arise because of the conclusions that they'd reached. But it was before them. And as I say, there's no cross appeal, there's no finding of notice in the sense of an internal management issue.
But my problem, Mr. Flynn, is more concerned, is more about the trial than the Court of Appeal, because as to how this arises, because if you're right and that the corporation, the society has the capacity, we then fall back on, we then get to the bylaw, don't we, which says that the board don't have the power, or there's a limit on the board's powers. I don't know if you're still there because we can't see you. But
I can hear you perfectly well.
To which then there's a question of whether there was notice or knowledge of the limit on the board's powers, and that issue doesn't seem to have been explored at the trial. We're being told that that these questions only came up, so far as they did incidentally, because of an estoppel argument.
Yes, my lord. And I obviously wasn't at the trial myself, so I can't answer that. But it does seem to me that the obvious point here is that it is for the society, the HCU, to raise a case of notice or bad faith. Now, as far as from what I've seen, there never was such a case. And it was for them to do so. They put their store very firmly in the case that they've put forward now, which was accepted by the Court of Appeal below, which is there's no capacity. Now, they didn't. You asked whether there was an alternative case. I don't have the material before me, but so from what I have seen, there was no alternative case of notice in the sense of internal material, as opposed to knowledge or notice of the external, which, as I say, we're taken to know anyway. So it doesn't really matter whether there's actual knowledge of those matters or not, i.e. the matters set out in paragraph 10 of the Court of Appeal. Now, it's said against me it wasn't pleaded, but it wasn't for my clients to plead this. Our case was, it wasn't a question of capacity, it was a question of power, and no case of notice or knowledge of internal matters was advanced. And there's no cross appeal. And I do, in my submission, I do think it turns on the cross appeal, because if there was a case of notice or knowledge against my clients of internal matters, that would be a matter that would have to be put forward in the cross appeal. And in fact, all that is said by the respondents is the Court of Appeal were right for the reasons they gave. So in my submission, if the panel is with me on capacity, we succeed on the appeal. There is no case on the alternative of bad faith or notice of internal matters, as I say, as opposed to those in paragraph 10 of the Court of Appeal, which is external material. So my lord, I understand why you raised that, but in my submission, it's no answer to the appeal. I wasn't going to say any more, actually, other than unless the panel had any questions.
I think it would be helpful to be provided.
Yes. We'd be assisted, Mr. Flynn, Mendes, if we could be provided with the written submissions below, so that we can see how these points were developed.
Certainly, my lord.
The other further documents if you want.
My lord, can I ask, what would be a sensible deadline for the panel to get
7 days.
Everything? And also, we would like the opportunity to respond, obviously not submissions, we can provide those, both sides as soon as the panel would like, but in terms of identifying any findings, we would want an opportunity to respond to that.
Yes, very well. Well, the pleadings below should be supplied within 7 days, and the further document requested by Lord Kitchen should be provided within 7 days, with a response within 7 days thereafter.
I'm very grateful.
Thank you. I don't think there are any further questions. There are not. Well, we're very grateful to Council, to Mr. Flynn, and to Mr. Mendes, and to those assisting them, who would normally be sitting behind them, but presumably are somewhere just out of range of the camera. We're grateful to you all. I do apologise for the technical failures which have led to the interruption in the hearing, but I'm glad to say that in the end it worked, and we were able to hear your submissions, for which we're grateful. The board will take time to consider their judgment, and the court is now adjourned. Thank you very much.
Thank you very much.